Get Into It. I am your host, Sherelle Higgins. Let's Get Into It is a safe space to have real conversations that are meant to uplift, encourage, and let you know you are not the only one dealing with life. Each episode of Let's Get Into It is designed to provide illuminating and thought-provoking information on a variety of topics. In fact, no topic is off limit. If you would like to see a topic discussed, please feel free to make a recommendation. My special guest and I will have a great time discussing topics that the mainstream media wouldn't dare discuss. We will bring these conversations to you with an open mind, respectfully, from different perspectives, and most importantly, with love. Thank you for joining me and my special guest. Now, let's get into it. Hello, everyone. I wanted to jump on here really quickly. I am Sherelle Higgins. I am the host of Let's Get Into It, and this is Let's Get Into It Real Quick. Couple things I've seen on social media where people are saying that they were probationary period employees and that they had 20 years of service at another federal agency, but they switched agencies and found out that they were on a probationary period. That should not happen. If you are on a probationary period, it should clearly be marked on your SF50, your Notice of Personnel Action. If you have career status, meaning that you have served at least 3 years in the competitive service and you move from one agency to the next, you do not serve another probationary period. Let me repeat that. If you are a career employee and you move from one agency to the next, you do not have to serve another probationary period. Now, of course, every rule always have exceptions. So one exception that comes to mind, when you are applying for federal positions, if you apply for a position that is open to all U.S. citizens, that means that position is being filled under delegated examining, and people who do not work for the federal sector can apply. If you apply as a federal employee under that type of announcement, you may have to serve another probationary period. And that varies from agency to agency. It doesn't always mean that you have to. So you should not be serving a second probationary period. If you are in the accepted service and you are someone like, let's say, an attorney, and you have completed your 2-year trial period, and you move from an attorney position to a non-attorney position and to in another agency or even the same agency, and you are moving to a competitive service position, you will have to serve another probationary period. And so make sure that when you are reading these social media posts that you look for those type of details, because the proof is really in the details. So I just wanted to kind of get that part out the way. The next thing I want to talk about is, and this is particularly important for employees who were let go and they were on a probationary period. While you have limited appeal rights at the Merit Systems Protection Board, you can file a prohibited personnel practice claim with the Office of Special Counsel. Now, the Office of Special Counsel's primary mission is to safeguard the merit system principles by protecting federal employees and applicants from prohibited personnel practices, also PPPs. And so there are 14 prohibited personnel practices. I'm not going to go through all 14 of them, but I recommend you do. You can Google it and it'll come right up. But I did want to point out one of the prohibited personnel practices says that any employee who has the authority to take, direct others to take, recommend or approve any personnel action, which would be your termination, shall not, with respect to such authority, discriminate for or against any employee for employment on the basis of marital status or political affiliation, as prohibited under any law, rule, or regulation. Now, I wanted to point that out. Oh, and also, they cannot violate any law, rule, or regulation implementing or directly concerning the merit system's principles. Now, I wanted to point that out for probationary period employees because I wanted to give you an avenue to pursue. And so don't be afraid to pursue it. Send in a request. Go on the Office of Special Counsel's website and find out how do you submit your request and submit your request. I'm not sure if you all have been following, but the person who is in charge of the Office of Special Counsel is a political appointee. However, when they are appointed, they have a certain that person has a certain number of years that they can serve. So they are on a term appointment. And so the administration tried to fire this person before that person's term was up. And the court said, no, you cannot do that. This person is going to be reinstated, which they were, and this person will fulfill the remainder of their term. And so this person is responsible for fighting for you if a prohibited personnel practice has been violated. So, probationary period employees, hear me loud and clear. I highly recommend you submit a request and ask them to take a look at it. They are pretty good at being responsive. And so you would want to at least take advantage of it and see if it's something that they can do to help you. I have a question in the chat. Why does it seem like the rules don't count under this administration, though? It seems like the rules don't apply because the administration wants us to they want to have the appearance of having authority and power that they do not have. And as long as employees don't know how to fight back, they will continue to exercise this power and authority without being stopped because we know both houses of Congress are the majority are the Republicans, and they are not going to push back against him, not yet, because they know that, as particularly those in the House, know that they have 2 years before they're going to be up for reelection. And so I can almost promise you that as we get closer to those midterm elections, they're going to start speaking out because they also want to stay in power and they do not want to lose the election because their constituents have been fired unjustly. And so, I think at this point, the administration is trying everything that they can to see what will fly. What can they get away with until their constituencies are impacted in a big way? Oh, absolutely. I think one of the things that people uh, uh, don't really know is that majority of federal workers are outside of the Washington D.C. area. And so their constituents are being impacted by everything that's going on as well. And I'm sure they are hearing from their constituents, and their constituents are not pleased. And so, I know we have as a country, we have shucked and jived when it comes to voting for a long time. And this is the lesson that we are going to learn about how important it is not only to vote for the presidential election, but to vote for the House races, the Senate races, your local governments, your school boards. All of those elections matter. And so, there are just certain rules that an executive order, or I should say certain law, there are laws that an executive order just cannot wipe out. That has to be an act of Congress. And so right now, of course, a lot of this stuff happened when Congress was in recess. And so we need to make sure as American citizens that we do our due diligence and that we are educated in what our rights are and how do we fight back and who's out there to help us, because we can't do this alone. And the Office of Special Counsel is out there to help us. Now, career status employees can also, if you are terminated, you can also file with the Office of Special Counsel and look at the prohibited personnel practices and see which one applies to you and use that in your argument as to why you were unjustly terminated. In addition to that, career employees are protected by the merit system principles. And there are 9 merit system principles. But the one I wanted to focus on today, again, you can Google merit system principles, all 9 will pop up. It's easy to find. But the one I really wanted to focus on tonight is the one that talks about employees should be retained on the basis of adequacy of their performance. Inadequate performance should be corrected, and employees should be separated who cannot or will not improve their performance to meet required standards. Now, the reason why I wanted to point that one out is because all of the letters so far, as it relates to people being terminated, talks about their performance. And as many federal employees know, your last performance appraisal was at least at the fully successful level, which is the minimum level of performance that you have to maintain. And so you want to make sure that if your letter says that you are being terminated based on performance, that you know your rights and you know what to do and what you should expect. The merit system principle goes on to say that employees should be protected against arbitrary action, personal favoritism, and or coercion for partisan political reasons. And so these are arbitrary actions that's happening. No rhyme or reason. Again, I'm sure you're following it. You see how they have fired people and had to rehire them. That's an arbitrary action, right? And so you may be getting terminated without your due process for arbitrary reasons. And so, again, you want to make sure that you educate yourself and you understand how the process works. And so, with the merit system principles, we are, as federal employees, given due process. So, if you are, let's say, for example, if they are saying you are having performance issues, you are entitled to a performance improvement plan. And prior to the administration issuing an executive order, agencies had the discretion of whether or not, when you are placed on a performance improvement plan, the amount of time that you would be on that plan. The executive order changed it to you have 30 days. And so you have to be given the opportunity to demonstrate that you can perform at least at the fully successful level. Now, this is for people typically who received an unacceptable rating. This is not for people who receive fully successful, exceeds, or outstanding. Typically, you don't put those employees on a performance improvement plan. However, it is part of the due process. So if your letter says that you are being terminated due to performance, that means they have skipped over the due process that you are entitled to and went straight to termination. one of the things that the agencies used to have to do prior to the executive order is also have be able to prove that the agency did everything that they could to help you improve your performance. Now, the purpose of a performance improvement plan is not to terminate the employee. The purpose is to help them improve their performance. And again, if you have not at least been given the opportunity to improve your performance and they went straight to termination, they have violated your due process. And therefore, you have a case that you can file as a career employee with the Merit Systems Protection Board to show that they violated your due process. And therefore, you are entitled to keep your job. So just make sure you understand that the minute you get a letter that says you are being terminated due to performance, immediately file a claim with and talk to an attorney always, 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 always talk to an attorney. Have an attorney with you, somebody who knows about the federal system is so important. You do not want an attorney who has to learn on the fly, right? You want somebody who has been fighting against the government for some years and they have some experience. But you want to file that claim because you have 30 days after you receive your letter and it's terminated to file a claim. File your claim. Don't be afraid of the process. Get you an attorney and file a claim because the administration, as much as they want you to believe it, they cannot um, strip you of your due process. So if they put in your letter that you are terminated due to performance, then you need to file a claim, particularly if you have proof that number one, your proof is going to be your last performance appraisal. Number two, if you have any emails that somebody said, good job, you're doing a great job, any type of written feedback that you've been receiving for doing your job, make sure you print that stuff off and keep it because that's going to strengthen your case. And so I recommend that for the probationary period employees as well. I know you probably locked out your system by now and have no access to it, but I hope you were able to print emails that show that you were receiving positive feedback because that is going to help your case. For my career employees, print those emails out now. Go back as far as you can and print those emails so that you have a record of your performance and how well you were doing. Make sure you have copies of your performance appraisal so that you can submit that as a part of your package to fight back against the notion that your performance was so poor that they skipped the due process and just terminated you. That's not a thing, and it should not be a thing, and we should not sit back and allow that to happen. If you if your letter says something else, then you need to know that you may still have some rights. Let's say, for example, if your letter says that you had some misconduct issues, you also, again, have a due process that you are entitled to under that misconduct. And most agencies, well, yeah, most agencies, is never an absolute, but most agencies have what they call a table of penalties for misconduct actions. And with that table of penalties, while it's not all inclusive because it's impossible to capture every type of misconduct that can occur, it typically has buckets of things that of categories that they use to find out where you are. And a lot of the table of penalties also have a section called not otherwise specified. So if you have some type of unique situation, then they would use the penalties for that. But typically, the penalties for a first offense will be anywhere from a letter of reprimand to, let's say, a suspension. And the agency has to make sure that whatever discipline they're going to issue to you as a federal employee that is consistent with the type of discipline that they've issued to other employees in that same agency that had similar misconduct. So if you are still working, pull down your agency's table of penalty and print it and make sure you keep it. It's on your intranet site, as you typically going to be under your human capital office, under your employee and labor relations section. So pull that down and print that off and keep that with you, because you just never know what your letter may say. If it says anything about misconduct, you want to make sure that you have that document. And also, they have to, when considering misconduct cases, they have to also consider something called the Douglas factors. And so I won't go into the Douglas factors today, but there are 12 Douglas factors. And basically, what the Douglas factors, the reason it came about is because there was a guy named Douglas, and there was actually three other uh, plaintiffs, but Douglas was the lead plaintiff. They were terminated from their jobs, and they challenged it and determined, and this was against the Veterans Administration. They determined that certain things were not considered when they were issuing discipline, and they actually was terminated. And as a result of that case, they came up with the Douglas factors. And so all of these things are written in your agency's policies and the Code of Federal Regulations and the U.S. law and the law. So you want to make sure, again, that you just educate yourself and you know what your rights are and the way that it's supposed to be, so that you know how to fight back against it and not just be out here vulnerable. So I wanted to just, get into it real quick and give you that information. I'm keeping my eye out on what's happening, and I will continue to come to you live. I will take the weekends off because I got to decompress from all of the information, just as I suggest you do. Just try to decompress from it all, not absorb too much of it. But I will come back to you next week, and we'll see where we are. If you have any questions, you can always DM me so that it's not public. I will be glad to, answer your specific situation, because again, the details matter. And so I'm here. I'm going to help you as much as I can. I'm going to give you the information that I think you need, and just kind of help you strategize around how do you protect yourself and protect your job. The notion of coming into the government and it being a safe place to work and you will be treated with dignity and respect is no longer a thing. It has passed us by, but I believe we're going to get it back. So thank you all for joining me. Again, if you have any questions, drop me a DM. I'll be glad to answer your questions. Have a good night and try to enjoy yourself this weekend. Thank you for joining and participating in Let's Get Into It. I want to thank my special guest for being brave enough to get into it. Without you, these conversations cannot happen. Remember, different viewpoints, respect, and love are the foundations of Let's Get Into It. If there's a topic you think I should discuss, drop me a recommendation. If you're interested in being my special guest, let me know, because we can and will get into it. Have a great day on purpose, and I look forward to your continued engagement and support as we get into it.